We invite you to know some of the benefits of the Panamanian Private Interest Foundation, regulated by Law 25 of 1995. The main thing is confidentiality. Some clients are very comfortable with the confidentiality that they can obtain and maintain through a private interest foundation. Although the name and address of the members of the foundation council must be indicated in the foundation charter, which requires registration in the public registry, the identity of the beneficiaries or the protector does not need to be disclosed in said document. The beneficiaries or the protector, if any, may be designated in the regulations, which is a private document that does not require to be registered at the public registry. Number two is assets protection and administration. The structure of a foundation makes it particularly attractive for asset management and protection. Furthermore, foundations are often used as instruments to hold shares in subsidiary companies, as well as to own real estate. In addition, foundations are also used as investment vehicles and even to manage bank accounts. Being a legal person, unlike trust, the foundation maintains a legal existence independent of that of the founder. Consequently, the assets of the foundation constitute a separate and independent patrimony for all legal purposes and cannot be seized or object of pecuniary measures except for obligations incurred or for damages caused due to the execution of the objectives of the foundation or for the legitimate rights of its beneficiaries. Number three is tax planning. As we have previously explained, the tax legislation of the Republic of Panama adheres to the principle of territoriality. Taking this principle into consideration, the law of private interest foundations of Panama indicates that the acts of constitution, transfer, transmission, or encumbrance of the assets of the foundation will be exempt from all taxes, provided that such assets constitute assets located outside of Panama, money deposited by natural or legal persons whose income is not from Panamanian source or not taxable in Panama for any reason, or shares or securities of any kind issued by companies whose income is not from Panamanian source or when their income is not taxable in Panama for any reason, even when such shares or securities are deposited in the Republic of Panama. The only payment to the Panamanian Treasury would be a single annual fee to keep the foundation up to date with respect to the provision of services by the public registry. Number four is state and succession planning. The foundation is usually used for succession planning purposes since it can be used effectively instead of a will and divide inheritance in a confidential and expeditious manner without any of the disadvantages of costly, complicated, and time-consuming probate procedures. Furthermore, the existence of legal provisions on hereditary matters in the domicile of the founder or the beneficiaries will not be enforceable against the foundation, nor will they affect its validity or impede the realization of its objectives in the manner provided in the foundation charter or its regulations. In view of the above, the provisions of forced inheritance in other countries will not be enforceable against the foundation, so that the wishes of the founder embodied in the foundation charter or in the regulations must prevail.